The Court of Appeals is now in session.
Good morning. Welcome to the Utah Court of Appeals as we continue to meet in virtual session. We appreciate your patience with all of that. Today we're convened to hear two cases that are being heard together. It's captioned State versus or In Re AH, and the case numbers for the record are 2021-0353 and 2021-0354. Before we get started, can I have counsel enter their appearances, please? Starting with counsel for the parents.
Alexa Marshall and Kirsten Norman for the parents.
Good morning.
Martha Pierce, attorney guardian ad litem for the minor children. And may I say, I love remote hearing.
Opinions differ, but I'm glad to have that feedback, Ms. Pierce. Thank you.
And John Peterson, Assistant Attorney General for the state of Utah.
All right, and good morning to you as well, Mr. Peterson and Ms. Pierce. Because there are two appeals being heard together today, we have decided to, I think Lisa's already told you all of this, to give each side 30 minutes. And so you can divide that up any way you'd like. I don't know if Ms. Norman will be arguing as well, or Ms. Marshall, if you'll be handling the entire thing for the parents. Is that right?
That's correct.
Okay. And it looks like you've elected to reserve at least 5 minutes of your time. And I don't know how y'all are going to be dividing it up on the other side between Mr. Peterson and Ms. Pierce, but that's up to you. You'll have half an hour as well. You're not obligated to use all of that time if you feel like you've told us what you need to tell us, but it's there for you to use if you need to. And certainly, as per usual, if we're asking questions and keeping you over time, we'll let you do that. So you all have been with us a number of times, and even in the virtual world, and so I'll dispense with any further pleasantries and instructions unless anybody has any questions about how we're going to proceed this morning. Okay, well, we look forward to your arguments, and we'll start with you, Ms. Marshall.
Thank you and good morning. In BTB, this court imagined a scenario where, despite a finding of unfitness, it would not be strictly necessary to terminate a parent's rights. To paraphrase, that scenario is where grandparents have come forward, are willing to care for a child, meet their needs, and preserve the possibility of a parent-child relationship in the future. If this case is not what this court imagined, then no case is. Here we have grandparents that are undisputably a loving, caring, capable placement that can take all 7 children in this sibling group. This family is unusual. It's large, and there are a range of needs across the ages of these children. That said, these kids are pretty much 2 years apart, all the way down the line. There is no large gap between the ages. And they've been moved from place to place throughout this proceeding, including back with the parents for after they were removed the first time. There are 2 legal errors here that led the court to this very wrong conclusion. The first one is the court failed to apply the presumption that it is in the child's best interest to remain with family. Wherever possible, family life must be strengthened and preserved. And the court made this error. Yes, Judge Appleby.
How much weight should we give to the fact that the 2 youngest children basically had no relationship with these grandparents?
We don't think that there's sufficient evidence to support that they had no relationship. They didn't necessarily recognize them as grandparents, but they did have a relationship in terms of how that relates to their ages. So they were very young, obviously, when they were removed, both first and the second time. But grandparents were involved in their lives. Grandmother came and cared for the youngest child when he was a baby. She has a relationship with the other children. And under the statute, kinship preference, both if you look at definitions of relative and friend, the relationship doesn't need to be with the children, the subject children. It needs to be with someone related to the immediate family of the children. So parents, siblings, anyone that's in that immediate group of the child. And here we undisputably have that. The grandparents have a strong relationship with the other siblings. Yes.
Would it be accurate to say that kinship placement is more significant earlier on in the proceedings, Or do you think it carries through the same weight through the ultimate decision at the end? Do you understand my question?
I do. And that sort of relates to what has often come up as like the 120-day timeline for kin coming forward. Here we don't have that issue because kin did come forward within that timeline. When the kids were removed a second time, almost immediately, I think it was within a month, counsel for the parents brought up the grandparents as a possible placement. And that's when the court ordered the DCFS to conduct the ICPC and investigate that placement. So almost immediately grandparents were involved. The only reason children were not placed right up front was because of that ICPC, because they are out of state.
Let me ask a better question. Substantively, if how does that work out though in the final analysis? That's my ultimate question.
So it still carries the same weight in the final analysis, and that's in the statute. So in two places in the termination statute, so not the adjudication, but in the termination statute, the court is required both to make sure that kinship placement was given due weight. That's in 104.12, and also in 301. The DCFS has part of the reasonable efforts is to place with kin. And that's in the termination statute. So the court has to make that determination as part of termination as well. In terms of substance, like how this works in reality, it is still very important, even if the kids have not been placed with kin throughout the course of the case, to be placed with kin as an ultimate determination, because it preserves that possibility for ongoing relationships with parents, with siblings, with extended family. Studies have shown that this is extremely important to a child in the long term. Sibling relationships especially are some of the most important relationships we have. They're the longest lasting. They have a myriad of benefits, including having shared experiences, having shared history, shared family. These are invaluable things that these two youngest children will no longer have because they've been permanently separated from their family. The kinship preference is important all the way through and ongoing. It is an important place that if we can place children with kin, even if they haven't been with kin throughout a case, that is still considered to be preferable than placing them with a non-related family.
Can I ask, there are points in your briefing where it feels like you're not really challenging the termination of your client's parental rights so much as you're challenging the post-termination placement decision made by the juvenile court. And I'd like to get your thoughts on that. I mean, there's even some points in your briefing where you say, hey, we offered to relinquish our rights if the children would be placed with these grandparents. And so it's at some level, are you even challenging the termination, or are you really challenging the placement? And if that's true, how do we get our hands around that?
Well, first, we are challenging the termination. And the reason we're doing that is because the other 5 children are in a permanent custody and guardianship with grandparents. So there was no termination as to them. And we are asking for the same thing to happen for the youngest 2, that they all be placed together in the same legal status of permanent custody and guardianship, which would mean that termination is not strictly necessary. So that is our request first and foremost.
But weren't the allegations as to the youngest children supportive of termination in a way that the allegations with regard to the older children might not support termination?
Let me make sure I understand. You're asking, are there different allegations as to the youngest 2?
Yeah, aren't the allegations as to the youngest 2 much more severe than as to the older children?
The only difference in allegations when it came to the parents was the failure to gain weight of the youngest child when he was a baby.
The failure to gain weight is a really passive way of suggesting or characterizing what I'm trying to suggest, which is that they were starving him.
Well, I wouldn't agree with that characterization either. All of their children, all 7, were born premature. It is just a genetic thing that happens with this family. And the youngest was no exception. And they've experienced the same fluctuation in weight gain and loss with all of their children that were premature.
But I thought that there was pretty compelling evidence that anytime that child was hospitalized, he gained weight, and that if the parent's characterization of what that child had been fed, he would not have been losing weight. So he gains weight when he goes to the hospital, consuming fewer calories than they claim that they're giving him. He goes home and he loses weight.
The record facts are not incredibly clear on that point. I mean, the court walks through sort of the weight gains and losses. The juvenile court walks through the weight gains and losses that happen. And in some cases, you have a situation like there's one one set of circumstances that the court calls out where he gains a pound a day after being in the foster placement. Well, that's not as a result of being fed that one day in the foster placement. I mean, the weight fluctuations are hard to predict with children in this age. But in any case, even if the allegations are more severe or different, it doesn't make a difference to this analysis because the parents aren't at this point asking for the children to come back to them. They're asking for the children to be placed with grandparents. And grandparents are undisputably capable caregivers. There's absolutely no dispute that they can provide the necessary requirements.
There you go, back talking about the placement. And this is back to my question. You know, you just said you're not challenging that they go back to them, you're challenging that they go to grandparents, but help me understand how, if at all, the decision to terminate is related or not related to the decision to what to do with the kids after you terminate.
Because if they go back to if they go to the grandparents, termination is not strictly necessary. And that's the point we're making here. We're really zeroing in on that strictly necessary language and that third option. So traditionally, there are two options in a termination case. There's termination and there's going back to the parents. But there is a third option, and that is what we are focusing on here. And that is an option that we believe is extremely important to child welfare as a whole. And it's really what this court and the Supreme Court were zeroing in on in BTB in terms of if there's another option here, if there's a family placement where maybe down the line that parental relationship can be rehabilitated, but most importantly, those children remain connected with their family, connected with their siblings, termination is not strictly necessary. And that's where that argument comes in. So even though we're talking about placement, because that's the real world effect of what we're talking about, it still goes to whether or not the termination is necessary. And here it's not, because we have a placement that's willing to take care of these children under permanent custody and guardianship, or we don't need to terminate. Does that answer your concern?
Yes, it does. And on that same vein, I want to sort of move to standard of review on this. In terms of what the standard of review is, in particular on the strictly necessary part of this. That is, I think, been determined to be a fact-like mixed question that we review with some deference. But in the mix here is the clear and convincing evidence standard. And I think, as I understand the case law, the state bears the burden of proving strict necessity through clear and convincing evidence. And I guess I'd like your summary of how what you think the state of things is in terms of how we review a decision by the district or by the juvenile court with regard to strict necessity as it relates to the clear and convincing evidence standard.
So there's two answers to that. When we're talking about whether or not the overall determination is correct, that's a mixed question. Like you said, that it is afforded some deference when we're talking about that overall determination. The clear and convincing standard fits sort of into that, and that standard makes the burden of proof for the state quite high, and we have to be pretty convinced that the outcome was correct in order to meet the clear and convincing standard. So there's that situation that's at play there. What we're also saying is that there is a de novo standard at play here because there are legal errors. So when there are embedded legal errors or threshold legal errors, as the Supreme Court has recently found in termination cases, those are not reviewed for deference. And we're asserting that there are two of those errors here that sort of are a threshold legal problem. One was not applying that statutory presumption and giving that deference to the family, making sure that we're putting the correct weight on the default position that it is in their children's best interest to stay with the family wherever possible. And the second one is elevating the foster family bonds, and the court very expressly did this, elevating the foster family bonds above all family bonds. It said we are affording the foster family the highest level of legal protection available. That is not what the statute requires. Bonds with the foster family are a factor that are considered, but they don't have legal protections in the statute. They just don't. The family does. The other legal error that we asserted in our briefs was the issue of not considering all of the children's best interest as part of a holistic examination. So again, going back to BTB, best interest requires a holistic examination. And here the court expressly said it was not addressing the best interest of the first 5 children, only the last 2.
Well, okay. Do you have any case law you can point us to that supports the notion that when we're, because we get split family cases, not often, but they're not uncommon, where you have maybe half siblings or step siblings or kids who are in the same home, but one of them has a really good place to go, so DCFS makes the placement and doesn't really worry any further, but then they come in and ask for termination of just one of the children's termination of rights just as to one of the children. And in that kind of situation, it does really seem that the courts are focused on the best interest of the child in question, rather than some of these other siblings or step siblings or half siblings that may be sort of in the child's universe. The difference here is that all 7 kids were originally part of the proceeding, and they only stopped being part of the proceeding on the eve of trial. And so that it feels a little bit different here. But does your argument extend to sort of these other cases where, the DCFS from the beginning is only concerned about one of the children in the household? And are you saying that in those cases, the court would have to be concerned about the best interest of all the children in the extended household, siblings, half siblings, step siblings, and so forth?
In a case where, let me do a little bit of a backup. So in a juvenile court case, each child is assigned a case number when they come under the jurisdiction of the juvenile court. That's how it works. So case numbers are by child, not by family. For each child under the jurisdiction of the juvenile court in a particular case, the best interest of those children must be considered, of all of those children must be considered. That's the court's job when it has those children under its jurisdiction. Here, all 7 children were under the jurisdiction of the juvenile court from the beginning all the way, like you said, until the eve of trial. And the only reason that the older 5 children weren't in the same termination trial as the younger 2 was because they agreed right beforehand that the placement with the grandparents was in the best interest of those older 5 kids. And that's an interesting situation here, because even though the state and the guardian try to make it seem, and the juvenile court try to make it seem like there's this large divide between the 2 groups of siblings, there isn't. They're almost perfectly evenly distributed across from 16 to 2, which is how their ages at trial. The difference between the older of Yes.
But doesn't that get back to my earlier question about the nature of the allegations of the abuse and neglect vis-a-vis the 2 youngest children versus the older children? And even now, I mean, you think about a child who was 16 then, who is now an adult,
Mhm.
may or may not even be with the grandparents at this point, or maybe not a lot longer. But that child is really fundamentally in a different situation or set of circumstances than a small child.
Absolutely. The difference between the oldest and the youngest is large. But when we look at the difference between the 4th child and the 5th child, or the 5th child and the 6th child, the difference is not that large. The next oldest child above the youngest 2, so would be the 5th child, he's only 2 years older than his younger sibling, and was throughout the entire case. And in fact, up until 3 months before the termination trial, he was actually placed with the 2 youngest siblings. For about 6 months, he was placed with them. So had this trial happened when it was originally scheduled in March of 2020 or in February of 2020, he would have been in the placement with those 2 younger siblings. And yet, DCFS was absolutely fine with him going with the grandparents. And there's just not a discernible difference between those 2 children, between the number 5 and number 6. Yes.
Taking you back to the line that you were just answering previously, that the state, or they quoted state OC
Mhm.
And quoted, although a juvenile court may consider sibling togetherness as one of many factors in determining best interest, a collective finding for the best interest of all the other children is not required. What should we do with that precedent?
I don't think we have any problem with that precedent because we're not asking for a collective finding. Best interest is definitely from each child's point of view. We take no issue with that. What we're arguing instead is that the court must look at each child and decide for each child as sort of a threshold question, whether it's in their best interest to be separated from their other siblings. And that's what we're saying did not happen here. The juvenile court looked only at the last two, and it needed to look at all seven to decide whether all seven individually, as individuals, whether it was in their best interest to be separated from their siblings. And had it done that analysis, it would have looked very different because it's very clear. What is very clear in the record is that the bonds between the oldest siblings, actually all five of the older siblings and the younger two, even though they were kind of one directional at that point, were very strong. They had a very strong reaction to being separated from their younger siblings.
Can I ask you just how that would work? What in this exact circumstance, what if the trial court, the juvenile court, looks at these two youngest kids on as individuals, makes a best interest determination that their bonds or they're not going to be that affected by being separated by their siblings. But let's just take the oldest child, the 16-year-old. They're going to say the 16-year-old perceives that there is a huge bond here, and it's going to be extremely disruptive and emotionally trying to take these two youngest children away from that 16-year-old. But we already have a stipulation for the 16-year-old to go to the grandparents. How exactly would the juvenile court then weigh how the 16-year-old is going to feel about it against what the court finds independently is the best interest of, let's say, the youngest?
So the way you
I know
phrase
that's
the
a
question-
convoluted question, but
No.
it seems to be what you're arguing.
Yes, but I think your question highlights exactly our error. So the way it was presented was, if the court's finding that the younger two children, they won't be that affected, but the older children will be. Well, the fact that the younger children aren't that affected one way or another is exactly why the family presumption exists. With really young children, it's really hard to predict how their relationships will develop. But it's pretty safe to say that if their older siblings are really bonded to them and have this care and love for them, that they will reciprocate it in the future, even if they don't right now. And the only reason they don't right now is because sibling visitation was not facilitated throughout this case. They had those bonds. The therapists at trial testified that the siblings did have those bonds in all directions. All of the siblings had them. They cared for each other. And the only reason those bonds got deteriorated was because they were separated and the ICPC took too long. And sibling visitation was not facilitated, which is the responsibility of DCFS. Essentially, DCFS created a situation in which those bonds were no longer there. And that's exactly where the family presumption is supposed to come in and make sure we're not separating families based on what is an artificial circumstance and byproduct of a child welfare case. The court created this false dichotomy between placing the children with grandparents and placing the children with parents and placing the children with a foster family where they were attached to the foster family and had these bonds. It's not a dichotomy. There is a range of options, and the range of options the best option for these children, the youngest two children, was to make sure that those long-term relationships that over their lifespan, they would have the benefit of still remaining connected to their family. And that's what that presumption is meant to do in the statute. Yes.
Before you run out of time, I'd like to hear from you about your claims of ineffective assistance of counsel. And I understand the problems with the retained counsel, but I'm having a hard time seeing it with regard to appointed counsel.
So our argument with regard to appointed counsel is essentially forced ineffectiveness. They had no communication with their clients for months before the trial. And that is because retained counsel told the clients not to communicate with them and told the clients, I'll take care of it. I'm going to tell them that I'm representing you. Don't worry about it. So the clients did not talk to their appointed counsel for months leading up to the trial, which essentially meant they had no opportunity to prepare. No witness list, no exhibits, no depositions, nothing. So they walked into trial with essentially no preparation and were just going off of their knowledge of the case and did the best they could with that, but with absolutely no witnesses other than what they were allowed to present from the state's list.
All of that.
Aren't the parents responsible for, I'm sorry, Judge Harris,
Oh, no, finish. Go ahead and finish. I thought you were done.
but aren't the parents responsible for having decided to retain a different counsel and going with that advice?
They're responsible for having retained that counsel, and that counsel is responsible for having completely misled them. And it would be unfair in the highest to expect these parents in a moment of absolute stress and strain, the worst moment of their life. They've just had their reunification services terminated. They're facing a termination trial on all 7 of their children, and they're panicking, rightfully so. They're panicking. And so they go out and they retain counsel with the limited means they have. And this counsel tells them, I'm going to take care of it. I'm going to get your kids back. He tells them everything they want to hear that their appointed counsel wasn't necessarily saying. And of course, they're going to believe him. Of course, they're going to trust him. To expect that parents should then distrust their retained counsel and nonetheless communicate with their appointed counsel, even though their retained counsel is telling them, I'm taking care of everything, that would be unrealistic to put that burden on the parents.
Yeah, and my question was, I think I shared Judge Appleby's view that I'm having a hard time seeing ineffective assistance on the part of appointed counsel when they're just acting on instructions from their clients that, hey, we don't need you to do anything. Everything does seem like it can be traced back to retained counsel. And I guess my question to you is, assuming arguendo that appointed counsel didn't do anything that could be classified as ineffective, you can still win this claim by pointing everything at retained counsel, right? I mean, you don't need to prove ineffectiveness of appointed counsel necessarily, do you?
I don't think so. I think if we can still show a significant prejudice from the fact that retained counsel so severely hampered parents' case, if we can overcome that prejudice prong of Strickland, I think that's enough to be able to make out an ineffective assistance of counsel claim. These children have a family who loves them and can meet their needs just as well as the family that they're. And while they may suffer some temporary detriment from being separated from their foster family, over the course of their lifetime, they will benefit from staying connected to their family and their siblings. And that's exactly the case where it is not strictly necessary to terminate parental rights. Thank you.
Thank you, Ms. Marischal. We appreciate the argument. We'll turn the time over to Mr. Peterson and or Ms. Pierce. I'm not sure who's going to go first and how you've decided to divide things up. Ms. Pierce, can you enlighten us on that?
Yes, we're going to split the time down the middle.
Okay. All right.
Again, with Judge Appleby's question about the severity of the abuse for the younger children, the statute is really clear that failure to thrive amounts to severe abuse. And in the criminal context, failure to thrive amounts to serious physical injury. And serious abuse, serious neglect and serious abuse is a carve-out for parental constitutional rights. There are 5 times in the Human Services Code and in the Juvenile Code that says that when you have serious neglect or abuse, there is no duty to provide services. And in fact, under 62A 4A201, that provides a litany of parental constitutional rights. And under subsection 6, one of the carve-outs is, except if you have this kind of serious neglect, there is no duty. So this is a serious thing. And this also goes to placement, because this is a child, LH, this is a child that if you turn your back, he starts losing weight. And so I think it may be asking too much of grandparents to say, yes, you can take care of all 7 kids. And that's a lot to have on anyone's plate. That kid is likely to start losing weight again. That's a very dangerous situation. So I think Judge Appleby's question is important in terms of services, and it's also important in terms of placement. I want to direct.
Is there any evidence in the record that the grandparents were? You just, I think, implied that if LH had been placed with grandparents, there'd been some concern that with all other 6 kids there, that they might not have been able to care for him appropriately and make sure that he gained weight. Is there any evidence in the record to support that implication?
I don't know if there's evidence to that, but I think if you look at the juvenile court's findings, there are findings that says that he has special needs and needs very focused care. And so I think the implication is there that we've got some foster parents who are working with him, who have their eyes on him, who can focus on him. So I think the findings are very clear about that. I want to focus this court's attention to paragraph.
I just want to make sure I have this right, though. I don't recall the juvenile court, even though the juvenile court did end up not sending these two children over to grandparents. I don't recall the juvenile court saying anything negative in her findings about grandparents. Everything was very positive about their ability to provide a home for these kids. Can you point me to anything in the district court's findings that was negative in terms of grandparents' ability to provide care?
No, I think you're correct. I think you're totally correct. I think what the juvenile court found was that this little guy was getting the focused attention that he needs, and the juvenile court wasn't going to mess with success given how fragile he was. And again, it seems like this is a matter of invited error because counsel already stipulated to the best interest of the older children being with grandparents. And now she's trying to say it's not in their best interest. And that's a matter of invited error. So you can't even get plain error when it's been stipulated to. I want to direct this court's attention to paragraph 70 and 71 of BTB. In those two paragraphs, the Supreme Court says you have to look, this is when they're addressing the state's concern that conditions of ASPA would not be addressed. And in BTB, the state was an amicus. They weren't a party because this was a private petition. And the Supreme Court said you have to look at BTB and that whole opinion in the context in which it arose, which was a private petition. And it said in cases, and in a private petition, the only chance a parent has to raise issues going to reasonable efforts and so forth and placement is at the trial itself. But where you have an underlying child welfare case, you have multiple opportunities to address issues going to reasonable efforts. And it also says that strictly necessary cannot be an excuse to set aside timelines and also permanency goals. And this child's permanency goal, these children's permanency goal has always been adoption. And the timelines in this case have just been flouted left and right. Indeed, after the failure of the trial home placement, failure of trial home placement is itself a ground, and the juvenile court gives them another round of services, and there's nothing in the statute that would support that. In fact, the statute says the kids retain the initial removal date, and all child welfare timelines stem from the initial permanency date. So in terms of reasonable efforts, I agree. Efforts were unreasonable to the extent that they went on for far too long.
Can you talk about the lack of sibling visitation during this time period? Can you address Ms. Marischal's argument on that point?
I can. Again, I think 70 and 71 tells you a lot because there are multiple opportunities that, and there's a reason that parents have counsel. There's a reason you have all these statutory reviews, and there's a reason that Rule 47 of the juvenile rules says that anybody can ask for a review. So if this were really an important issue, then counsel had multiple opportunities to raise that claim. At the time, it would have made sense to raise it. The fact that she delays until the termination trial tells you a lot. And in fact, and that brings me to In Re KC. And what's the In Re KC is 2015 Utah 92. And that was an ADA claim. But that was where the parent wanted to insert a component into the service plan at the time of the termination trial. And that was ADA. And the Supreme Court said, when you wait until the termination trial to say, wait a minute, the service plan should have contained XYZ, you can do that, but you can't use it as a critique about past services. It instead really is a bid to reopen the reunification service. It's a bid to reopen the reunification period and add this new component. So if this were something that they wanted to be in the service plan and they waited until the termination trial to ask for it, then it was a forward-looking component. It's not a backward-looking component. And if they were concerned about it, they had multiple opportunities to raise that claim and to raise it to wait to raise it at the termination trial, I think this court should consider it in that context. Let's see. I don't have much more to add except for I gotta say, I am the 7th of 9 children, and the fact that you're going to look at these children as a collective to me is horrifying, given the special needs that the 2 younger children have. And the law even treats younger children very differently in that it says when children are aged 3 and under and cannot return home, then the permanency goal shall be adoption. It treats them very differently because they have a very different conception of time. And as to the 16-year-old, if he has a strong feeling toward these kids, well, 16-year-olds, if they want to contact anybody, the last thing they do is say, well, do I have a legal right to do this and should I call my lawyer? A 16-year-old knows how to contact anybody at any time in ways that people of our generation can't even imagine. So I think in terms of being able to contact each other, that can happen. And foster parents have already received training that these kids are not blank slates. They come with a history, they come with the connections, and they have training in terms of what connections to foster and what boundaries they need to impose. So unless this court has questions, then I'm going to turn over my time to Mr. Peterson. Seeing no questions, I'll thank you for your time.
Thank you, Ms. Pierce. Mr. Peterson?
May it please the court, John Peterson, Assistant Attorney General for the state of Utah. I'd like to kind of jump in, I believe, where Judge Appleby kind of started off. We're just talking about the very real differences. I mean, and Ms. Marichal suggested these are 7 kids just separated by 2 years, just one large sibling group. But in fact, there are very real and substantial differences in these children. And as Judge Appleby noted, I mean, obviously for LH, who was basically starved. I mean, it's unclear what happened, but it's very clear that he was failing to thrive in the parents' custody. Removed, instantly starts doing better. Returned to them, instantly starts failing to thrive. Removed, instantly starts doing better. You do the math. But it'd be more important. Oh, yes, Judge Harris.
But nobody's suggesting at this point that the children be returned to the parents, right? And so I think the argument Ms. Marichal is making is, we've got these grandparents over there. They're willing to take even the 2 youngest kids with whatever special needs they have and keep them all together. And there's no indication in the record that these grandparents were unable to provide the sort of care that these kids would need. So why not give the sibling bond some weight here?
I mean, I think the juvenile court gave it weight, but I mean, I guess it's the situation is there. I'll start out saying the grandparents, obviously, like you say, there's nothing wrong with them. They're by all accounts wonderful people who stepped up and are willing to take 7 children into their home, which is even that they're their relatives, it's a lot. I mean, and it's admirable. But though notwithstanding the issues of failure to thrive, I mean, when this case started out in 2017, LH and AH were 1 and 2. I mean, they were little kids, and given the course of these proceedings, they were back at home. They have just never had a chance to really live with an extended sibling group with their parents. I mean, their developmental needs and they're simply different. I mean, something to say why can't all 7 kids go with your? Oh yeah,
but this is the point I think the other side is making, is that why shouldn't we give them that chance if there's a good opportunity to have that chance, given the importance of sibling bonds over the course of a 70-year life, right? It may have been better for them over the next 6 months. It would have, we're sparing them the trauma of the next 6 months to take them from their foster family with whom they clearly have a good relationship. But in exchange for that, we're depriving them of 70 years of sibling relationships. How do we go about dealing with that issue on review here?
I mean, I think that the idea that this is maybe just like a 6-month blip in their lives, I think is not necessarily accurate. I mean, these for all accounts purposes, their foster parents are their parents. These are the people they have lived with more than they've lived with anybody else in their life. So removing young children who have already had a lot of turmoil in their life, I mean, there's a lot of studies that talk about adverse childhood incidents, and the more these things happen, the more you start impacting them permanently. I mean, so I'm not saying it would happen, but there's a definite chance that removing them from the stable bonded placement they're in will be more than just a slight change in their life. And then, and what to what? Because they don't have a sibling relationship. So it's the opportunity to maybe develop a sibling relationship, but they also have an opportunity to develop relationships in their foster and with the extended family. I mean, you're talking about a potential. They don't really have much of a relationship with the parents or their siblings. I mean, it's unfortunate, but the way these things have gone, and a lot of that's the parents' fault. If the parents had taken care of them properly, they'd all be living together as a family. But numerous things have happened, and we attempted reunification. It didn't work. But this is where they are now. So that the idea that, I mean, that we should gamble upon their future to give them access to build some relationships that don't exist and tear down the one solid relationship they already have, I mean, I think is great. It's high speculation. I mean, I think that's definitely an area where the juvenile court is entitled to some degree of deference to its decision as to what is actually in these children's best interest in the future. I don't know if that's responsive to your question, Judge Harris.
It is very much so. Thank you.
And I guess I would move on to maybe talk about the council issue a bit. Again, I think it's there's two facets to it, as Judge Harris noted, and Judge Appleby also noted. The performance of Mr. Banks and the performance of appointed counsel. There's a number of strange issues here. One thing I pointed out in my brief is the fact that Mr. Banks didn't appear on behalf of both parents. That's simply not true. I mean, it's very clear from the record that he appeared on behalf of father. And when he asked for a continuance, mother's counsel said, I don't even really have any opinion on that whatsoever. I mean, there was two things going on there. I mean, so that's one factor, that his appearance was limited. And all we really know is that the parents reached out to him and he appeared at the day of trial. Father, basically, well, his affidavit, oh, yes.
Well, all we really know now in the record, that's true. But if you go and read those texts that are part of the 23B motion, we have a lot more information there that the court obviously would need to make some factual findings about on a 23B. But isn't that the point of 23B is that, or its equivalent in the juvenile court termination realm, is that we can go find those facts and figure out, did they actually retain him? Did they pay him money? Did they tell him to enter an appearance and he didn't? And if those facts are true, then the fact that he didn't enter an appearance on behalf of both of them, I mean, is kind of neither here nor there, right?
Yeah, I mean, procedurally, 23B doesn't only apply in criminal cases, but I mean, I think this court has inherent authority to order remands if you want. I mean, so whether the rule necessarily considers that or not.
Well,
but
I mean, I wrote on this myself a year or two ago about how the rule clearly doesn't apply here, but we have over the course of the years sort of de facto applied it here, and that may or may not be correct. But nobody here is asking us to revisit any of that. There is therefore a 23B-like process that applies here, and so when I refer to 23B, I'm referring to sort of the shorthand of whatever we want to call that 23B-like process that applies in termination cases. So anyway, I think that's where we are. I mean, do you disagree?
No, but I mean, I think I would say that even were you to remand to make these facts, I don't find those facts to be all that important. I mean, it's very clear that they tried to retain him. I mean, there's maybe some disagreement about who told them not to communicate with counsel, but with their former counsel. But father's direct testimony under oath was it's all his fault. He threw himself in the risk court. He said, I'm sorry, I made a mess of this. I tried to retain counsel. I decided, yes, Judge Mortensen.
Well, I recognize what you're saying is academically accurate, but this kind of begs the question. You see that this judge is shutting you down on the basis that your retained counsel didn't do anything that he told you were going to do. You're at a trial that's looking at terminating your parental rights. I don't know that I would be that comfortable foisting him on that petard of saying, okay, judge, it's my fault. I think he's just trying to pacify the person in the room with all the power. Would that be fair to maybe look at it that way?
That could be one characterization of what happened. I mean, but I mean, and Judge Appleby.
As a practical matter, if we were to remand it, hasn't this attorney been disbarred?
He has.
So any remand would involve only the parents and probably only the text messages, right?
I mean, I suppose, I mean, there's no reason you can't subpoena somebody who's been disbarred. I mean, he wouldn't be acting as a lawyer anymore, but I mean, he could be a factual witness. But I mean, again, I mean, things could happen. We could remand it, but again, I mean, the council were there. I mean, these are their council. They've been the council. This is a very long case. They've been council for a long period of time. And again, all they basically said is, there's a couple of witnesses. We want to have the older kids testify. We want to have like the kid's first foster mother testify. They weren't even an interesting witness. And again, the parents waived. They said, fine. I mean, they agreed. We'll just call whoever's already on the state's list, regardless of whether the state's called or not. That was an agreement that was made. Again, and so really, what do you have? Like, what is the only claim to error about the former council is that they didn't call the older kids and the first foster mother. But I mean, the facts of this case are the facts of this case. You could have everybody.
Well, let me interrupt you there, because I get your point that the earlier foster parents, the farther you go back in time, the less weighty their evidence is going to be as to the current relationships. And so I guess your argument is the farther back that goes under a usual 23B analysis, it can't have been that prejudicial, so why remand for it? However, the testimony of the siblings does seem to be fairly material, since the juvenile court's making findings directly on that issue. What is the relationship between the siblings and the two youngest kids? And the court not only makes findings, but reaches an ultimate conclusion that there's not much of a relationship there. If that's the way the juvenile court's looking at the entire evidentiary picture, how can we possibly say that not having them or having them testify wouldn't have made any difference, especially when we don't know exactly what they would say?
I mean, the court found that there were. I mean, that from one side, from the point of view of the older children, yes, there is a bond that they do feel strongly. But again, I mean, I've already.
It's one thing for them to say, "Oh, they feel strongly," but what if they get on the stand and they give concrete examples of what the actual nature of the relationship? Isn't that potentially pretty compelling?
I mean, I guess it's in theory, who knows what he says, but really, I mean, I think it really comes down to their needs and their wants and their desires. I mean, and the inalienable facts of this case are that these two younger kids just have not been around, have not been a very integral part of this family unit for most of their life. And even if the older kids all testify that they had a wonderful, strong, meaningful relationship, and in their opinions, there's nothing really to suggest or contradict the juvenile court's findings that just didn't go both ways. And that's unfortunate, but that is the case. And you can't change the fact of the history of placements. The juvenile court in its order set forth. I mean, and there's a lot of things happen, a lot of things change, and there's been a lot of disruption. But the only real consistency the two young kids know is over a year and a half with their foster family. That's their whole world. I mean, and the fact that it's unfortunate the older kids may feel, and they probably do feel, a very strong connection, and the juvenile court recognized that. So having the older kids come in and testify that they have this connection that the juvenile court understands they have, I don't really believe would have meaningfully changed the outcome of this case. I think I hit the points that I really wanted to address. I mean, if there are further questions of the court, then I'll allow Ms. Marichal her rebuttal. Thank you.
Thank you, Mr. Peterson. Ms. Marichal, back to you for rebuttal.
Thank you. A few points, and I'll kind of go in reverse order. So as to having lived as a sibling group and the relationships, these kids absolutely did live together for significant periods of time, not only before removal, even though they were very young, but also for a year between almost the close of the first case. So all of the kids went back to the parents, lived with them for almost an entire year, and then were removed again. And that year was at, I believe, ages 3 and 4 for the two youngest children. So salient ages for them to live with all of their siblings. And then again, as I mentioned, they were placed with all of their siblings at one point after the second removal, very briefly. And then also their next youngest brother, the fifth child, was placed with them for 6 months, right up until 3 months before trial. So they did live with their siblings. They did have a relationship with them. That's part of the problem in this decision, is that it doesn't take into account any of those facts. And for that reason, the testimony of the other siblings would have been very important, as would have the former foster parents, not because it goes to the current state of the two youngest children, but it goes to how these children have reacted to changes over time. The first foster family at the point of trial had actually been the foster family that had the children the longest, longer than the foster family that had them currently at trial. And they had seen the children through multiple changes. They'd seen them go back to their parents, come back to them. They could testify as to how the children reacted to that exact issue of being taken, going back to their parents and going back to foster placements, changes in caregivers generally. That's why their testimony was so valuable, because they would have testified, and this was in the affidavits, they would have testified that these children are resilient. They have this, temporary dysregulation, as is completely expected in all these cases, but they can overcome that and build those strong relationships again with their family. And that's exactly what the statutory presumption is there to fix. That's what it's there to support, is to make sure that we're not artificially cutting off the importance of those bonds just because DCFS wasn't able to facilitate sibling visitation or wasn't able to find a placement for all 7 children. Had DCFS had the ideal world and been able to place all 7 children in the same placement, we wouldn't be having this conversation at all. There's no way they would be arguing that there are no sibling bonds between them. It's only because they weren't able to facilitate that. I also want to point out that the argument that, oh, well, it's unfortunate that they don't have these bonds, but that's the reality we're dealing with now, is a big problem for child welfare cases, particularly when you're dealing with newborns. If a newborn is removed from a mother, as often happens in cases where you have substance abuse during pregnancy, not the case here, but it is cases that happen. If the argument that, well, this newborn doesn't have a bond with their parents, so we're going to terminate rights, that would happen in every single case. And that can't be right. That's exactly why the statutory presumption exists. It's to counteract what happens naturally in the course of a child welfare case with these removals. And we can't terminate solely on that basis. I also want to take issue with some of the factual issues that the Guardian raised. First of all, nowhere in any court papers does it say that these parents starved the child. That word does not appear. It's not in the record. In addition, there was never a finding of severe abuse or neglect. There was a finding of abuse and neglect on stipulated 34E plea facts. There was no finding of severe neglect. We cannot impose that now. That's completely inappropriate. So it was not argued in the brief. So that's just not a basis to make any decision here, because it's completely unsupported by the record. And finally, the idea that the older siblings can still have a relationship with their younger siblings, they can just pick up the phone and call the foster parents. There is record evidence that that's not possible, or at least not very easy. At record 1615, there is testimony that the current foster parents limited phone calls from the siblings and grandparents to 1 hour per week. And it was only during a very specific amount of time. So it was made very difficult in order to keep those sibling bonds. And there's no reason to think that, particularly once there's absolutely no legal reason to keep that contact, that the foster family will. So that shouldn't play into this analysis at all. Really, this is about strict necessity. That's what this case is. And that's the legal problem that we have here. The court did not do this analysis correctly. It should have started from the default position that it is in these children's best interest to remain connected to their family. They had a perfectly good placement that is undisputably capable. There are no findings that grandparents could not take care of who is now a 6-year-old. The youngest child is now 6. So there's no reason to think that he's so fragile that if he goes back to them, he'll suddenly start losing weight. That's completely unrealistic and not in the court's findings. These kids have a placement that is family, and that's where these children should go. That's exactly what strictly necessary requires, and that's what the statute dictates. Thank you.
Thank you, Ms. Marischal. You can have all counsel come back on screen for us to thank you for your participation today. This is an interesting case. I think it's been well argued and we're well advised in the premises. Thanks to you for your briefing and your argument. We'll take this matter under advisement as we almost always do, and we'll issue a decision for you as soon as we're reasonably able to do so. So anyway, thank you for your participation today. The court now stands adjourned.
Thank you, Your Honors.